Once the mitigation plan was presented, it was to be implemented within 6 months.
Okay, so why doesn't your own staff have a plan? Why do you have to utilize the services that the town contracted for their information? You've got engineers on your staff. Why haven't your staff come up with a plan 4 months ago when this all started?
We've ordered the equipment. We have a plan that calls for a specific equipment. The determination of the question is which turbines are going to be utilized on that equipment. And we want to work with the town in respect to that, A. And secondly, is the equipment enough? Or maybe in lieu of the equipment, we determined to shut the turbines down for a period of 6 hours in July and August.
Okay, this be done now in the meantime till this is
Could do it right now.
Because
If we can have an agreement that we can sit down with the engineer, with Epsilon, we're willing to engage them, we're willing to pay for them. If we can sit down and have access to your town engineer, Epsilon, and craft a plan together so that we have one plan presented and approved by your engineer, this could be done in 3 years.
But just backing up, you said right now, and I know through a telephone, that those turbines can be stopped. So while this is all going on, just until this is resolved, can't something be put in place? That's what we're looking for.
Right, but now's not the time to do it because this isn't the time period in which the flicker is the most aggressive. We're talking about really the summer months. We're talking about July and August, and that is the time period in which I think the most impact is, and I think that's what you heard at the October
Well,
meeting.
we heard it was a year-round problem, not just July and August.
Well, it's a question of hours. So if your report says 37 hours and 28 minutes during the course of a 1-year period,
I'm not sold that that's the most accurate report, because I can't get anything that says that this can be verified. So it could be more than 37 hours, it could be less.
Worst case scenario was 120 hours.
So it could be between
So
the
it
two.
could be between that.
Um,
And also, when these things were built, the equipment was supposed to be on those things, that somebody could just dial up the computer or dial up with a phone or whatever, and shut those things off when somebody was, complaining about flicker. So when they were built, the equipment wasn't installed on these things. So from the get-go, it wasn't right.
I can't comment to that. I don't know. I wasn't at that hearing. I did review your special use permit. There's no specific condition with regards to that, so it's unclear. But what is clear is that there's no objection to putting that equipment on the units. If we can get confirmation as to which units would be most beneficial.
But I think it should be on all of them.
Maybe that's the determination. Maybe that's
Because
the
that's
ultimate
what was
outcome.
explained to us.
Again, I don't know what was explained to you. I wasn't at that meeting,
I don't-
but
I
I don't have that
board
special.
member That's
I don't
gonna
have
lie
a-
to you and tell you something different.
No, but the point is, it's not on the special use permit as a particular
No, but it was
condition.
part of the testimony to grant the special use permit.
Testimony. Unless
So-
we take all your testimony and throw it out, is that what you're telling me? Your testimony was useless, worthless?
Mr. Chairman, you know that I'm not saying that.
Well, that's what you told me, if it wasn't, if it's
No,
not
I'm
written on
saying that.
it.
You throw out the testimony, I'm not saying that. And I'm not saying that it's all useless. It's clearly not. It's important. My point is, for this discussion, and for this resolution, what we're proposing, what we're asking is, allow us to work with your engineer. We'll pay for it, and allow us to craft, it's your engineer. We'll craft
Well,
a
I'd like to hear-
mitigation
I'd like
plan
to hear
together.
the legal justification as to why Mr. Wagner is opposed to that.
Mr. D'Onofrio, we've been explaining to Attorney Mancini and his clients for the better part of 3.5 months at this point that it is the town's preference to maintain the independence and objectivity of its own consultants. And when we were here in October, Mr. DePasquale testified at length about how he had consultants capable of doing it. He testified at length about how his data is not substantially at odds with Epsilon's, and we instructed them to move ahead with their own in-house expertise. We are going to retain the independence and objectivity of our own consultants in the event that we need them in the future. And that's what they've been told, and they have decided not to proceed on their own behalf using their own experts.
But my concern is, you don't need our permission to hire a consulting company. What's to stop them just going to Epsilon and trying to get their own contract? They don't need our permission.
We've tried, and Epsilon will not work with us
Well,
because of the conflict.
that's Epsilon's choice, that's not.
No, that they're being told not to work with us.
So,
because of the town.
can I chime in
Please.
for just a second? It was the recommendation of the council for the town, the solicitor, that Epsilon remained independent. And for months prior to this even coming up, we've been telling WED that that's going to remain that way and that they don't need to work with them. So we've heard this a number of times and it doesn't seem to be, it's never clear to us why that the inability to work with one particular engineering firm prevents them from remedying the issue. It's still something that I quite frankly don't understand, and I've heard a number of times. Mr. DePasquale, I believe, has not only in-house engineers, but I also believe he's hired a number of consultants over there.
Well, it's based on the scope of the projects, he's ongoing projects now across the state. I think they have plenty of engineering firms they can be tapping into.
So that's just the backup, but I'll just remind you why we're here.
I just wanted a legal justification as to why the town does not.
So that was a recommendation from the solicitor, and it's been long-standing, and it's been communicated to Mr. Mancini, Mr. Rossini.
Is that common practice in this type of case?
I don't know if it's common or not. In litigation, it certainly is common that each side would have their own engineer. I know that Mr. Wagner looked for someone to consult him when he was considering this NOV, and there were precious few engineering firms who could do it. Most of them were hired by either Mr. DePasquale or other wind energy companies, so they were conflicted out of their work. So it's one of the few that we were able to get, and we felt it was important to maintain their independence. And again, I don't see, and I still don't understand why working with one particular engineering firm is the thing that's blocking turning off these turbines, either automatically through some type of module or manually with a computer, which I'm told they can do, to abate the violation. So with that said, and
Well, thank you for that. I want a legal justification as to why that was in place.
So
Thank you.
why we're here tonight, because I just want to put it in the procedural context so you don't get too far in the weeds. There was a notice of violation issued quite some time ago after a warning. That came before you at the last meeting. You were listening to some evidence, you listened to some argument, and instead of voting as to whether to overturn the NOV, you gave the parties, you held it in abeyance for 30 days.
Which has been stretched out now.
So that they could reach some type of solution. I think what you're hearing from your town planner is that a solution has not been reached. So I think, again, you're here on an appeal from a NOV. You have to make a determination as to whether the NOV was issued with clear, either is the result of clear error, lack of the weight of the evidence, or procedural error. And if you don't find one of those three elements, then you uphold the NOV. But that's what we're here. We're not here to really reconsider all of the evidence as it was put in, but rather to look at what the building official looked at and determine whether he was supported by some form of evidence.
Didn't we also direct them to come up with a plan?
For 30 days.
You held the whole thing in abeyance for 30 days, come up with a solution. I think what you're being told now is a solution has not been reached. And of course,
Okay, what is your, this letter dated, what was it?
October 26th.
October 26th. What is your opinion on that letter?
my opinion is that it's,
Well,
if you want my opinion, it's not a plan, it's a continuation of an effort to delay over months and months what could have been done in a matter of weeks or days.
Right.
That's my opinion based upon my interactions, but.
Okay.
Through the chair, a few points. First off, if the issue and the concern with regards to using Epsilon is the independence and whether or not they cannot or the town cannot use them in litigation going forward, I can certainly speak to the client about waiving that right so that you're not conflicted. If you want to use that, of this engineer in litigation going forward, that's fine. I don't think that that is of concern to us. We want to use them, so we wouldn't have an issue with that. So
Why
if
do you want
that's-
to use them? You have
Because
other firms.
I do. Well, there's two things. One is, the town's already confirmed and they've used them, so they're comfortable with them. So if this engineer signs off on a combined plan, then I don't feel that,
But they're comfortable using them, they're not comfortable with you using them.
no, but we would be comfortable with using them, so that if they okay the plan, which the plan is the installation of the equipment on the selected wind turbines, and they're okay with that plan, then why would the town not be okay with the plan if their own engineer has accepted it and signed off on it?
Are we talking about the equipment that, the modules that they can go in and they can shut down the turbine at any time when there's flicker
No.
issues?
No, so the equipment that's being discussed and what was described at the October meeting is the fact that it's automatic. So it's a system which automatically analyzes, determines the amount of flicker, and closes or shuts down the turbines.
Okay.
So that we don't do it manually, there's no
Okay,
delay in
just
that
for the
process.
record, I got one thing. Keith, you heard this, you were here for the
Yes,
meeting,
sir.
correct?
Yes, sir.
All right, so I do have, Jenny has to leave, Jenny Susi, so I want to make sure I have a full board of business. 1, 2, 3, 4, and 5. You okay,
And
Susi?
you were all here for the previous
That's what I'm
meeting.
asking.
Yes, sir.
Okay? You're okay with this?
I am.
That's essentially the plan. The plan is the installation of these automatic modules, and I don't know what the proper terminology of it is. We're prepared, we've actually purchased them, we have them, they're coming in, being designed in Germany. The point is before we isolate them, meaning where do we put them, how do we orchestrate them, whether or not they're acceptable, we want to sit down and work with Epsilon.
But you have engineers that can tell you the same thing.
But they're not your engineers, but if you're.
But do you have engineers that can tell you the same thing?
Yeah, we do, we have in-house engineers, are you willing to accept that?
Well, we just submit the report, so we can review it.
But we've described in the correspondence, so the other issue I take is with the fact that this is trying to be a delay tactic. It's not. There's been a tremendous amount of communication between my client and Mr. Brusini and Mr. McGilvery with regards to this, and overall, in fact, as early as last week, we met with the town council in trying to negotiate a global settlement on some other pending issues. So this is not something that this company has buried its head in the sand and has disappeared. We have been in discussions with Mr. McGilvery. That letter on the 26th identifies what we think to be the beginning of a mitigation plan, which is this equipment. This equipment that goes on the turbine and automatically monitors the flickering and shuts it down.
Okay, so that equipment's installed, right? It automatically monitors and shuts down. That's all we're asking.
Yeah, but what we want is confirmation from your engineer that that's acceptable, because we think that that should be the
It's not
standard.
acceptable because it was already supposed to be on. That's what, see, this is what we're missing the whole point. This was already supposed to be on it. Now, whether you want only, you say it's not in the, well, not
The
agenda-
decision.
in the decision, and we're saying, wait a minute, this is how we made our decision on this information that was given to us. And because it wasn't directly, we didn't write the whole, and I'm saying what, in that decision, not only is what was written, but the whole documents of the hearing. And that's included in it. So if you don't want to take the documents of the hearing, then like you say, we throw it out and we throw out the whole
The
thing.
decision.
Yeah, either way. You got your choice. Either do it or don't do it. Do what you said you were going to do, or don't do it.
Well, I don't know what type of equipment
Well, I'm
was
saying, well, then
discussed.
read the decision, then read the hearing.
Then
You
what-
can, you can read the hearing as well as anybody else.
That's fair. So then what I would request is an opportunity to pull that file, to pull those transcripts, to see
You gotta
what.
be kidding me, you haven't done this in this many months?
I don't know what the equipment was that was described in there. What I know is the equipment that's proposed now may not be the same equipment that was proposed then.
What we
It
just
is.
described is exactly.
It was a generalized equipment that could shut it down anytime. Now, you're asking a bunch of laymen, not engineers, to know exactly what type of equipment was addressed. No. We went on
Mr.
the
DiPasquale knows
opinion.
what kind of
Exactly.
equipment we talked about. He was here presenting these things way back when. he knew what was in the testimony, he knew what equipment was needed on those things, and he didn't follow through. My question to the solicitor is at some point, do we have an opportunity to withdraw the special use permit for these things?
Not that I'm aware of, but that's something I can look into, but that's not something I can opine on right now.
I would appreciate it if you would look into it, because I'm getting a little bit tired of Mr. DePasquale and WEP, pushing everybody, delaying everybody, and just not,
I take
and just
offense to
not
that.
following. You can
Well,
take offense to it all you want, sir, but Mr.
I'm just-
DePasquale told us in this room that these were gonna be equipments that were gonna be put on these machines so that they could shut them down when flicker was bad, and it didn't happen. And you're still, and it's a delay tactic as far as I'm concerned. And as far as I'm concerned, you want access to our engineer because you want to spin the story your way. And I agree with Mr. Wagner, that that's not gonna happen. You guys have enough money, you guys have enough resources to hire your own engineers, put together the report, and let our engineer take a look at it and see if it's a workable report. That's what I think should happen.
Well, if I may, and just, again, we're just preserving the record, I respectfully disagree, I understand your point, but no one's here trying to spin a report. It's your engineer's report. We're actually wanting to work with your engineer so that we have one engineer that the town finds acceptable, rather than get into a battle between engineers and a battle of trying to understand, complexities developed by engineers when we're all laymen in this field. We work with one engineer, your engineer, you've chosen, we pay him, and we devise up a mitigation plan.
But at this time, that's been taken off the table.
That's off the table, that's
So-
off the table,
So now we
so
need
let's
to-
move
okay.
on, what are you gonna do?
So let's go to Plan B,
Okay.
okay? Let's get this resolved.
Yeah, we've been trying to resolve, you want to go to Plan B?
You use your engineers, and as Vice Chair
No,
suggested,
what's the NOV?
we'll have
Well,
a,
then, if we can't use Epsilon, then we'll use our internal engineers and we'll produce to you our report for our mitigation plan, which is gonna be the installation of this equipment. And the Plan B to that Plan B
Solicitor.
may be the shutdown of the turbines for a period of time during July and August. The time period in which we believe to be the most problematic time period.
get this guy some relief.
And this, by the way, has been relayed on multiple occasions to the solicitor, both orally and in
So
correspondence.
whatever relief, let's just get Mr. Sullivan some relief. That's what we're asking for.
Can I
He's
just-
suffering, let's get him some relief, and just put all the stuff aside, let's get
We
it
have
done.
no objection to that. We really honestly don't. I mean,
That's
I
why we're
don't-
here.
Can I-
We're not here to delay it. We're not here to hide.
I'm gonna chime in for a second. The notice of violation is not for lack of a plan. We keep talking about the plan,
Oh, we know.
like that's what everybody,
We know.
if we have a piece of paper, that's gonna make things somehow better. The notice of violation was because the building official, right or wrong, found that it was violating the special use permits in the ordinance. That has not been
Disproven.
ameliorated,
Hasn't been disproven either.
nor has it been fixed. So whether there's a plan or not is not what the NOV talks about. It talks about fixing the problem. And, the way the NOV works is the fine continues until you stop the violation. So if you have to turn the things off manually for a while to stop the violation, while you come up with a plan, you can do it that way. But this, I think, getting lost in discussion about when some type of report's gonna be presented, who's gonna
I
present
agree.
it, is not what the notice of violation is about.
And if I may, the point here is a resolution, a practical solution to rectify the situation. Putting aside the NOV and the legality of the NOV and whether it was proven or not proven, the question is resolution. That's what the board wants, that's what the board expressed in October, and we don't want to be reappearing here arguing the same issues. We also want a resolution. If the decision is you don't want us to use Epsilon, and you want us to use our engineers to develop a plan, then that's your
But yet
prerogative.
the violation still exists, it's still ongoing, until it's resolved.
So does the fine for the notice of violation that goes
Yes.
on and on and on until the problem is fixed.
Yes.
That's why we're here in the first place, as was just addressed, it was a violation.
Then we can just address the violation and we just address the fine.
That's what the initial
Okay,
appeal is for.
then just, you fine us, but there's no resolution to that. you know, and it will go on, and that's not what we want. It's not what we're looking to
Well, I don't think
to
you
come
want
up.
that, 'cause the fine goes on as well.
What did you say about something before, the fine goes on as
It
well?
goes- so that's- I said, I don't think that's what they want. I think
No, we don't, we want to resolve it. We don't want to fine, we don't want to hurt neighbors, we don't want to hurt the town. We came up with a hope to work with your town engineer. If you want to keep your town engineer as your litigation chip, that's fine. Then we'll use our inside engineers and we'll develop the plan. And then if it becomes a he said through engineers, I don't think that's, then I guess the board has to decide whose engineer is more credible than the other engineer.
But in the end, it's not about the engineers, it's about the equipment that's supposed to be on there, which would monitor us automatically.
Exactly.
It doesn't matter what the engineers say.
Yeah, it's about the resolution, it's about, you know, we're gonna tell you the equipment, which turbines the equipment's gonna go on, and we'll have that as the plan, and then we'll.
But if you do that, and the problem continues, then you got, but they have to get all the turbines, not just
That's the
certain
walls.
ones. It doesn't matter. This equipment should be installed, and the equipment should determine when the flicker's happening, and then should shut down the turbines.
Yeah.
That was what the equipment's supposed to do, and was supposed to have been installed initially. So it doesn't matter what the engineers think based on expectations or worst case, best case, the equipment's supposed to do that.
Yeah.
In real time scenario.
Yeah, I don't think that's unreasonable. I mean, look, we're talking about one receptor, and I think that the goal is to resolve that one receptor. I don't know what the necessity is of having it on all the equipment, but if that's something the board wants us to really analyze and do,
That's what we were told, that's what we want.
okay.
So
But
that-
how are we gonna solve this now on this one structure?
Well, I think on this one
That's
structure,
not
we're
the
proposing to
issue.
do it on, well, I mean,
When's it gonna be done?
well, we can have our inside report by our next meeting.
So what about the equipment? When am I
The
doing it?
equipment, I believe, is on its way. We should have that this month. The equipment was ordered. The equipment is
How
probably
about we
already
shut down
shipped.
how about we request, Mr. Wagner, shut this down until you have the equipment installed?
We will appeal that.
We'll appeal it.
We'll appeal that. We'll appeal that. If we don't want to be, if this is an issue of
Because
us
we
versus
give you plenty
them,
of time.
well, we've tried to work with your
No,
town
no,
planner.
you're not trying
All
to
right,
work,
then-
I told you point blank.
Then, you know, here's the example, you know, we were not notified of Epsilon being here tonight and presenting a report, and we weren't given due process to defend ourselves and have an opportunity to review that documentation. That doesn't happen, and Mr. Wagner is very aware of that. In court, that does not happen.
But I want a solution.
Well, I'm here,
I don't consider what he gave tonight a solution, I'm gonna lie to you.
I
I mean,
don't,
it just gave
I'm not
you
even,
direction.
I don't even know,
All it did is assist you in a direction of travel.
I,
But you gotta point blankly, do something. And you said to me, "Brian, oh, don't worry, we'll solve this." I don't think you have. I don't think you've come forward with your correct intent.
again, I respectfully disagree with that. We're coming forward with clean hands and trying to mitigate it and trying to resolve it. Okay, but I think that there is a block here with this Epsilon report, and if you're telling us that, okay, you want to keep that as your litigation chip, that's fine. Again, so
You
the
know
bottom
there's a
line is we're
problem.
getting.
You know there's a problem, there's no maybe about it, before you know there's a problem, you know you gotta solve it, but you haven't put the foot forward.
No, honestly,
It's
the
out.
only bearing this Epsilon presentation of tonight was, it was your client that brought up Epsilon as being a worst case scenario. That's the only reason why they're here. To me, that has no bearing on whether or not there's a violation, what the Epsilon report says. Even what he said tonight has no bearing on me or whether or not there's a violation.
But it has a bearing on what the mitigation plan is, and that's why we want to use
Sure,
but you have to have a
Epsilon, because
violation.
we want it, but again, there's the problem is a struggle as to whether or not we're working cooperatively or whether or not we're going into litigation. And I understand the town wants to preserve its rights in going towards litigation, but what we're proposing, what we're saying is, there's a global long-term solution. So the Epsilon report goes to that. I don't think the Epsilon report, my argument in October stays the same. It doesn't prove the violation. The Epsilon report gives you a range, and it's still a question as to whether or not it's a worst-case scenario. You know, we can go into all the details we talked about in October, but the primary point of the Epsilon report is to find the receptor that's most problematic and to see if the equipment that we want to employ will solve that problem.
Is this your position right now that you're still contesting that there's an actual violation?
I'm reserving that right, absolutely. I'm reserving all of the arguments made in October, and we're not changing any of those arguments. We want the chance to even rebut this Epsilon report that was presented tonight, that we weren't aware of it. We're not here tonight to present a case, we're here to give you status on where we are with the resolution and
What have
going
you
forward.
done?
I'm sorry?
You haven't solved the problem.
We believe we can and will solve the problem with the equipment that we
You told me
have.
that in October.
No, we said we were gonna, well, what I'm saying now is, we're giving you, our position coming here today was, we wanted the opportunity to speak and work with your
Don't you
consultant.
think we've been more than fair giving you all this much time to solve the problem? We didn't come in that night and say, shut it down, and didn't give you an opportunity. You've had more than enough opportunity.
I think the board's been excellent, I have no question with that. And I'll be honest with you, my client believes that Mr. Wagner is the obstacle here. That not having the access to the report, there was a delay in trying to get to the property. They didn't want, for whatever reason, they delayed the inspection of the property. If you want to say that we're delaying and dragging this out, we feel the same of the town administrator, your zoning enforcement officer. So we don't want that. We want that to be eliminated. We want to work with your town engineer.
We're only here now because the job wasn't completed correctly when they were built. So you guys, WED, didn't finish the work, which has precipitated this whole problem. The notice of violation, the flicker issue at number 287, everything that Mr. Wagner has to deal with, all comes down to your client not doing what he said he was going to do.
So the client installed 10 wind turbines.
Uh-huh.
Okay, and we have an issue with one receptor. Okay, and we're prepared to resolve that one receptor issue.
You're prepared, but why haven't you?
Because, again, we want the report from Epsilon. We want a mitigation plan approved, solidified with Epsilon. And
We don't
say,
have
this is
enough
it.
engineering and knowledge to say which engineering firm is better or which one has the correct amount. We don't have that.
But you've chosen your
These board
engineer.
members.
You've chosen your engineering firm. We agree with the engineering firm. We don't want to disagree with them. We want to pay for their report. We want to pay for them to work with us in solving.
Mr. Wagner has
mitigating.
chosen it, and he's not a professional engineer, all right? Now, I'm expecting you to have the professional engineers to solve the problem. This is only one little thing in the background that we have for checking our odds and ends. The burden is up to you, not the town, not anybody else. The burden is on you to solve the problem. Until you get that understanding, and we've given you plenty of time. Now, I'm gonna ask the solicitor right now, I don't understand why we can't just shut it down now. They've had time, we've given them everything, I don't understand why we can't shut it down.
The issue before you is whether to uphold the NOV, and I don't think the NOV calls for the turbines to be shut off right now. So I think that the issue before you is whether to uphold the NOV, which will continue to find them until they find a solution.
So what I'm hearing is you want an engineer to find the best way to resolve the problem. So that, to me, says you're admitting there's a problem, because you need an engineer to solve it.
No, we want an engineer to affirm that whatever mitigation plan we have is acceptable. So, and we're not.
Mitigation plan to resolve the problem.
Well, are you trying to get me to say that there's a problem? I'm objecting to the NOV, I objected to the NOV. I still say there's a key difference in what we're arguing here, and what's gonna be a legal issue that's gonna get determined. That is it 10 combined wind turbines that caused the problem, or is it 30 hours per wind turbine? That's gonna be the legal issue that gets defined and determined. That's what was argued in October. So, we're not saying, we're saying there is no problem.
Would it be in your best interest to use your own engineering firm to show that there is not a problem?
No, it's not, because we believe that if you have already an engineer that's acceptable, that's knowledgeable, that gave a report and analysis on this, and we show them what we intend to do to address their concerns, and that engineer incorporates it into his report, it's done. That's our position. But if you want to have one report that says one thing, and then another report that's going to say that we believe that these are the wind turbines that are problematic, this is where the equipment's going, this is how we want to solve the problem, and present that.
I think you're trying to say,
Well, yeah.
you want us to direct you on how to solve the problem.
No, I'm not. I'm asking you, actually,
We're
I'm
not
going to solve.
gonna do this.
the-
This is your problem.
It's our problem, wind turbines,
And I'm not gonna tell
wind
you which
energy is.
turbine's doing. Again,
I'm not
that's
asking
your
you to, I'm asking you to engineer, I'm asking a qualified, third-party, independent engineer to define it.
But you're looking to cherry pick which turbines you want to put the equipment on. When the original hearing was, you were going to put the equipment on all 10 wind turbines, and it would solve any kind of flicker issue for anybody, as serious as Mr. Sullivan's is, to somebody who's not that serious.
And I'm not saying we're not doing that, I'm not saying we're opposed to that. I'm saying that the outcome may very well be that our proposal is to put the equipment in all of the wind turbines and get approval and clearance from the engineer that says, we think that that's going to satisfy the expected flickering.
So you're trying to see if there's a cheaper resolution?
No, I'm not trying to put a cheaper
Yeah, but the
resolution.
problem
Stop, just do what you
is,
said to begin.
I don't believe you're operating correctly without this equipment on it.
Well, the
I don't
special
think
use
you're
permit,
operating correctly.
special use permit specifically indicates that there wasn't to be,
Special use permit and also the testimony given at the meeting, not just the special use, unless you want us to throw that all out. And I'd be happy to and start all over on these wind turbines. If that's what you wish. You don't want to take any of that testimony in.
To get a certain
In
special
there.
submit, certain standards have to be met.
there's no question, listen, we're not arguing, I'm in agreement with you. The language on the condition of special use permit is that, then it says, if there's flicker, it says, in existence at the time of this approval is experiencing over 30 hours of year of flicker from a turbine, and the responsible party for the wind turbine shall mitigate the flicker so that the home does not experience more than 30 hours of flicker per year. Okay, so that's, we have no disagreement with that. That's recorded, that's our law. So what we're saying is we have the means to minimize the 30 hours per year of flicker. We want it to be confirmed by Epsilon. It's one report, one methodology.
I don't even want to take that report into account right now.
Okay.
I just
so then
want
you're
you
we want our inside
do
engineers to do it.
what you're supposed to do. All right, now, also, I don't want to hear that, oh, it's this one. As far as I'm concerned, I think you're operating illegally. The whole thing. And what's it, NOA?
The NOV.
The
So,
NOV should be upheld. Point blank.
Let's
No
go
names
for a
about it.
vote.
You tell me.
but
I don't see how.
upholding the NOV just upholds the fines. It doesn't uphold it doesn't solve the problem. That's
I
what
agree,
we're-
I think they should be
that's-
shut right down. I don't think just this one, I think all 10 of them should be shut down,
Okay,
because you haven't done it correctly.
okay, and
It's
that's,
just like building a structure.
well,
If I don't put the fire alarm system in, I can't get a certificate of occupancy. I don't think you got your certificate.
well, I think that's certainly a very broad legal conclusion that's far afield from the NOV.
No, it
So
don't.
I don't think
This
that that's in
we-
play, but if you want to
We
make that
didn't have enough
decision.
knowledge when this went up to make you have a certificate. And I think that's part of what's required. Because we were lied to when we were told that it was probably all done and ready to go, and it wasn't. The burden again is on you to prove that you did as you testified to, and you haven't. I don't know how the board feels, the rest of the board,
I agree with that.
but
We felt that the standards were met for a special use permit based on the testimony given to the board.
But
That's
there's no revisiting, we're not asking, well, I don't think the board has jurisdiction at this point to revisit the issue of the special use permit. The issue before you is the NOV. And I respectfully request that you allow us an opportunity to rebut Epsilon. If this is going, so we're not going towards resolution, we're gonna go towards the NOV. I want an opportunity to respond to Epsilon's testimony
we have
tonight,
no,
because I wasn't given any,
no choice.
I was given no notice of that, so I don't think that's It's a violation of our due
But
process.
the testimony given tonight from Epsilon has no bearing on whether or not there's a violation, as far as I'm concerned, as a board member.
But that doesn't mean that I'm not entitled to a right to respond to that and be given a
You
timely
can have the right
opportunity
to
to
respond
respond.
to anything you want. I want you to solve the problem.
I want to, my client wants to solve it for me. So-
Well, you've had all this much time,
Can I just chime in? Again, you're just here for the NOV.
that's what I'm
The
saying.
appeal on the NOV. You're not having a new hearing about whether there's a violation or not.
Exactly.
You're only determining whether the building official
Eric.
erred in the issuance of that NOV, based upon what he's told you he's considered, or that there's an error of law in its issuance. So that, I think, you've heard the evidence, you've heard argument, unless I think there's something further that you want to hear, it's probably ready for a vote.
And to the board, just to refresh you, in October, we're kind of in agreement that he did not err in his judgment, but we were being
Courteous.
lenient to maybe soften the impact by giving them time to come up with a plan. And that
Exactly.
didn't happen.
Did not happen. Not even a plan, but an action. So at this time, yeah, I'd like to have a motion to uphold the NOV.
Mr. Chairman, I'll make that motion.
I'll second that.
Before the board votes, I did prepare a brief outline on what is in the notice of violation, just to make sure, and also to provide a calculation on the penalties through this evening. So just to be clear, the notice of violation asked for WED to present a mitigation plan for the flicker within 30 days and to take immediate steps to stop the flicker, presumably by manually shutting down the turbines at the problematic points in the day. So that's what you're voting on. And it also imposed a fine for, the reason we're here now, because of the delay. Obviously that fine wasn't enough to promote the results we hoped to get, which was a prompt response to this. But that's what the fine is in the notice of violation.
I agree with the NOV as issued and presented to us tonight with the fines. In fact, I think you're almost being lenient, because I feel that all 10,
But we did not issue the notice of violation as to all 10 turbines.
no, I know you didn't, that's what I'm saying. I think it should be for all 10, since they were not erected correctly. But at a minimum, I'd like a vote, motion made on upholding this NOV at this time. Do we have a motion on that?
Yeah, motion in a second.
A motion and a second. Okay,
Just say, I had John motion, Denise seconded.
okay. All those approved of the vote tonight, say aye.
Aye.
Nays? Ayes have it. Okay, John, Keith, I'm gonna start off with a roll call vote with you.
I vote to uphold.
Okay, John,
I vote to uphold.
Denise,
I vote to uphold.
Chair votes to uphold. Russ?
Uphold.
Okay, the NOV is upheld at this time. And that's it.
Mr. Chairman, I make a motion we adjourn.
Motion we adjourn. Brian, you have anything else you'd like to add?
No.
Okay, how about us, Russ?
No, I'm for adjournment.
Okay. I have a motion to uphold, do I have a second?
Second.
Second. Okay, all those in favor say aye.
Aye.
Nays? Ayes have it. Thank you all for coming.